So what exactly is a trust? Well, a trust is where it's a legal document in which you have the grantor or settlor, that in this case would be you, putting your property under the name of a trust. And when we talk about a trust, we're usually talking about what's called a living trust or a revocable trust. Now, what happens is you put the name of your property in that trust. Let's call it the John Smith Living Trust. So if you had a piece of property in your name, John Smith, now it would be owned by John Smith Living Trust. You, as the grantor, would be putting your property into the trust. And usually, in most trusts, the grantor is also the person who is responsible for administering the trust, or what we call a trustee. You may name other people who would be trustees in case something happens to you, you become incapacitated. Then you might have alternate trustees who would be responsible for handling the property just like you would have. Now, again, the advantages of a trust in estate planning is that, again, the property that's in the trust, first, it's usually, if it's a living trust, it's revocable. So at any time you could decide, oh, I don't want this property in the trust anymore, I'm going to take it out of the trust. And you can do that without any sort of, there's no legal, no violation of any laws. If you have a loan on a property, typically those loans will allow you to put it into a living trust or to take it out of a living trust so long as there's no change in the percentage ownership. So if you own a property, or let's say you own an interest in a commercial property, let's say you own 30%. If you transfer your 30% into a living trust, then you haven't changed anything. So you won't trigger any loans, etc. You aren't violating anything. You aren't triggering any sort of sale that would cause an assessment of a real property to be higher, so you pay more property taxes. Those kind of things are things you don't have to worry about. So why do we have, again, this living trust? Well, again, so it's revocable, but also it's a way of controlling how your property is going to be transferred upon death, and it's a way to avoid probate fees, because if you have a will, or if you die without a will, or it's not in trust, then your property must be probated in court. Another advantage, again, is that because it is not probated in court, the property in the trust will be transferred according to the directions in the trust, that it will remain private. It does not have to go through any court procedure. Only if somebody challenges the trust, in which case they would file some kind of lawsuit to become public. But assuming nobody challenges it, then it all stays out of the public eye. Now, again, there are not, generally speaking, it's not really done for taxes, unless, well, we're talking about a situation where you have, let's say, over 25 million in assets, and you're married, and you're doing this in a way to transfer the entirety of that estate to your children with the least amount of taxes paid over both your lifetime and your spouse's. And for that, basically, I would say talk to your attorney if that's one of the reasons why you're doing the trust, or if you're not sure why you have to do it, or again, these are things to discuss with a legal professional so that they can design an estate plan that fits you and your needs.